Brandon, let me know when we're ready. Okay, everybody, please take your seats. We've got a great crowd for the always fantastic presentation here in March, the annual What the Estate Planners Can Learn from the Estate Litigators and Administrators. And interestingly, we've kind of focused more on choice of fiduciary, which for me, out of the CPA world and years of experience, what a mess those can all be. So a lot of insights will be coming. We're just going to go through quickly some announcements. Certainly one I want to introduce you all to is Mark Hardkey, new president of Northern Trust, both here and in Orange County. So welcome, Mark's over here. Thank you for coming, Mark, down from Orange County. A couple of preliminary announcements. Many of you have seen that the extended due date for San Diego County is June 17th, automatic, likely to be extended again based on last year's experience, but this covers not only filing of tax returns, paying the April estimated payments, making IRA contributions and beyond. So certainly be aware of that. I'm sure your CPAs have told you, or they haven't, because we want to keep it moving and get it done anyway instead of procrastinating like what we experienced last year. The other point of note, I'm not sure if everyone's aware of the Corporate Transparency Act, which is really an anti-money laundering act that came out of Congress, effective January 1, 2024, requires some basic filings that need to be to identify the beneficial owners of entities, numerous rules and exceptions. A business with more than 5 million of revenue or 20 employees is exempt from filing, but that got declared unconstitutional, I think, on Friday. So and that was a district court, I'm not sure where. And some kind of questions, what's that mean? Is it going to be unconstitutional across the country? And so we don't have to worry about it. But we'll keep you posted as we find out more information. Certainly, many thanks to the folks that make this all happen. David Jacobs of Acumen Insurance Solutions. He makes the website and the whole registration process goes well. Libby Tate of Windward Life Care for our registration, check-in, and name tags. Brandon Robbins and Glenn Arnold for our greeters. So glad you all could help with that. Roberta Robinson and Dan Wilson of Robinson and Wilson Attorneys at Law for getting us qualified for MCLE with this state bar. We've got Barry Levine of Northern Trust, who was instrumental in getting us all set up with the CFP organization for continuing education, not only for this year, but for all of the 2023 programs as well. A heads up, our April 2nd meeting is going to focus in on a presentation, panel presentation led by Charlene Wallach, the Chief Impact Officer at the Jewish Community Foundation of San Diego, how to have conversations with your clients on philanthropy and charitable giving. So really not to be missed. They're going to provide you with the language to use when you're talking with your clients. Unfortunately, us CPAs and attorneys have had no training in this. I just believe in it. RJ Kelly just believes in it. and make a difference, leave a legacy. So we've cobbled together the language we use. But Charlene is so eloquent in her presentation, in her discussions with clients, and she and her panel will kind of share that with the rest of us. Mark down May 30th, which is our next social event with Aspirient, led by Paul Hines, Karen Clapp, and Sandra Connors. More information to come, but just put that down on your calendar. Upcoming events, we've got May 7th, first Tuesday of the month, as always. Rebecca O'Toole and Sarah Pike of Withers Bergman will present on the new California legislation, directed trust. Great tool. Not sure if it's as good as Delaware, but Rebecca will be certainly all over it. June 4th, we've got Thomas Pawlowski, a JD, Senior National Director, Trust and Estate Planning at Bernstein Private Wealth Management. He's going to present on kind of current state of the economy and its impact on current estate planning opportunities. July 2nd, we've got Robert Valero, hopefully with one of his real estate families that he works with, to share insights and experiences that they've had with in that planning for real estate families arena. I want to certainly bring up our next person, Jordan Horn, and his business, The Estate Sale Guy. He's sponsors of today's program, and we'll let him take it from here.
How's it going, guys? Good morning. I just joined the group last month, so this is my first time speaking, but it's my second meeting. We're casual, fun, and we get it done. We do estate liquidation and real estate. We team them together. A little different niche market within itself. You can go to the next slide, please. There we go. So I've been in the estate liquidation business for 16 years, real estate business for 14 years. My grandmother was a high-end antiquities dealer and art broker on the Monterey Peninsula, Pebble Beach area. When my mom was probably about 20 years old, she decided that she was going to get into the estate liquidation business. And 30 years later, it became a full-on career for her. I grew up in and around the business. And from there, branched out, and I'm a little bit nervous. I've never spoken in front of this many people. Anyways, branched out from her and opened up my own business. I was with Coldwell Banker since 2019. And from 2019 to now, I have my own brokerage, and we kind of do smaller in-house deals, and we kind of go from there. Next slide, please. We take pride in what we do. We normally sell the home along with doing the estate sale, and we go the extra mile. We do what we need to do, start to finish. We do more than the average estate liquidator because we are selling the home. Next slide. Once we're hired, we come in and we set up all the rooms, we stage, we organize, we categorize, we display. We bring in tables with lacy tablecloths, lighting if need be. If there's jewelry, higher end items, we bring in cases as well. If there's a dining set, let's say you have bone china, stemware, flatware, we're going to go ahead and set up the table as if you're having a dinner party so people can see what it looks like out and about. Setup time usually takes anywhere from 3 to 5 days. And then from there, we do all the advertising and marketing. We're there Thursday through Sunday, 9 a.m. to 4 p.m. each day. Next slide, please. So if we're selling the home, we go ahead and market the home through the estate sale as well. The home usually is the big ticket item. And at that point, we get about 1,500 people through a home in a weekend. So we add all the information for the home on estatesales.net, .org, Craigslist. We do signage throughout. And then obviously everything on MLS auto-populates to Zillow, Trulia, Redfin, Realtor, and all those sites. If we're selling the home, we put on MLS is an open house. So those people can come in and see the home during the estate sale itself. Next slide. So once everything is set up, then we come in and we basically price and label everything. So if there are any brand name, designer name, maker name on any of the stuff in the house, we go ahead and put that on the price tag so that we can drive up the price and kind of go from there. We do signage throughout the house, more out back, watch your step, more this way, not for sale. Obviously, real estate sign out front, just listed, open house signs, so on, et cetera. Next slide. So during the open house and the estate sale, we limit the number of people who come in the house. One of the reasons we do that is we build a sense of urgency. And with the sense of urgency, everybody is coming out and they have stuff in their hands and people are like, hey, I need some of that stuff as well. Also, if you have too many people in the house, people can't see what is for sale. Things kind of get broken at that point. There's too many people in each room. They can't see the house itself. We have music playing throughout. I'm there. There's a few other people as well. There's only one entrance and exit, and that's going to be through the front door. So we can monitor who's coming and going with what. On the real estate side of things, if there are people who are interested in the house, they can come back multiple times. It's 9 to 4 through Sunday. So at that point, if they come back Friday, Saturday, Sunday, they bring contractors in, stagers in, friends of the family in, and then they go ahead and write an offer. Then at that point, we kind of have a little leverage because we know that they came in 4 and 5 times, and then I saw them while they were there. Items for, what do we got? So, so just during the house, we're circulating, talking to people. If the house again is for sale, we have full color informational flyers. If the house isn't ready for sale, a lot of the times the people want to have the house cleared and then they want to have flooring, paint, upgrades, whatever done. At that point, we can have a informational flyer of what the house is going to be listed for, when it's going to be listed, what they're planning on doing, and we kind of build a clientele up at that point. If people want to put minimums on stuff, they can. And obviously we won't sell stuff for less than that. Once the estate sale and the listing or open house is over, if they want the house cleared, we can have it cleared as well. So every cabinet, cupboard, drawer, closet, pantry would be empty. The total time is usually 2 to 3 weeks start to finish. Again, it's like 3 to 5 days to set up and organize, categorize, display. Then we do all the marketing and advertising. And then from there, we come and do all the pricing and labeling. From there, we do a 4-day sale and open house. And then it's usually 3 to 5 days to break down and clear out the house after that. The goal is to have the house cleared out within the next weekend so that we can have it cleaned, rephotographed, and then it goes on the market, is vacant with lockbox. Or if they want to stage it, they can stage it and again, photograph it and go from there. So that's kind of what we do in a nutshell. My presentation wasn't as great as I hoped. I'm a little nervous up here. It's okay. So anyways, it's a streamline effect. It works nicely together. A lot of the times we do get more offers than the average realtor because we do have about 1,500 people through a home in a weekend. And at that point, they just work nicely together. So that's kind of what we do in a nutshell. I do have flyers and cards on the front table if you want to grab one on your way out. And, we would like to try to stay within the high-end markets here in the North County area. If I have the estate sale or the listing on a property, I'll take any estate sale. If it's just the estate sale, then I'm going to be more selective. And that's kind of what we do. All right.
Thanks so much, Jordan. Filled with great information. If you'd like a copy of the PowerPoint, email me or Jordan from his card. Certainly want to introduce you to our next nonprofit spotlight person, and that's Ali Colbrin of Feeding San Diego.
Hi, everyone. Like Bill said, my name is Ali Colbran. I am with Feeding San Diego, and I'm honored to be here this morning. I have a video that I wanted to share with all of you. But before that, I just wanted to say a few words about us. So Feeding San Diego's mission is to connect people facing hunger with nutritious meals by maximizing food rescue. The San Diego Foundation released a report last fall that found that 35% of families living in San Diego do not make enough every month to cover their basic living expenses. And food is a huge part of that because food is a variable expense. You can't pay half of your rent. You can't pay half of your electricity bill. but you can certainly cut back on food in order to meet your bills. So people are skipping meals. They're skipping meals so their children can eat. And that's where Feeding San Diego comes in, because there's enough food for everyone. We are wasting food across this country every day. Almost 40% of food produced in the United States is wasted every single year. So Feeding San Diego steps in and rescues food all across the county and up and down California to connect it to people in need. 90% of the food that we're distributing is rescued food, and we're connecting it to those families in San Diego. So I wanted to share a video with you that tells us a little bit more about our work, but also features the families that we serve.
Working in a grocery store, it's funny, you get to see just how expensive things have gotten. For example, we had oatmeal, instant oatmeal. It was on sale, $5. Wednesday, it's instantly gone up to $8.99. Eggs used to be super cheap, 99 cents. Now you go in for a thing of eggs, it's almost $6.
The most money expense in home is food. When we got all these extraordinary expenses, make hard sometimes because we need to stop buying goods because the prices are increasing.
I'm a single mom. My son has autism. Even though he's high functioning, he has a lot of needs, and it makes it very difficult for me to be able to hold down full-time employment. Oftentimes, even if I have employment and I have childcare, I often lose the childcare because they can't take care of him, but then I can't work.
For like CalFresh, there's a certain income limit, there's a certain requirement that you have to be under, family size, but they don't take into account the cost of living that's gone up, the great, amount, everything's more expensive now. You have to make gross under this amount, but I'm a single mom, 3 kids, I make too much money. There's no way.
I thought I was okay. I thought I had a degree, I have work experience. Surely I should be able to provide for my kids. But they're just, things that you don't plan on in life.
Through my victim advocate for domestic violence, they gave me a list of resources that had different food distribution places, and Feeding San Diego was on there.
It's a game changer.
We're at Southwestern hosting our 200th Together Tour, which is a large-scale drive-through distribution, where we are hoping to help more than 2,000 families in need. And we bring close to 80,000 pounds of food. We have about 60 volunteers helping make it happen.
The pandemic started something that a lot of people think is over, but it's not. Each individual car represents a family that is struggling.
First of all, you feel welcome. Everybody there is nice. Everybody says hi. Everybody's like your family. It's like your neighbor, they know you.
It really helps, especially putting fresh produce and meat on our table.
I've gotten chicken before, or there'll be ground turkey.
The meat, the tuna, the pasta.
And then we get usually produce. There'll be fruit, usually potatoes or onions.
Peanut butter, the Feeding San Diego bring us peanut butter with banana or apples with peanut butter.
Getting people out there to be willing to ask for help, it has to be a positive experience from the start. All stigma put aside, just looking at someone for someone. Everybody struggles from one time. We're human. We all do.
As of the years, I was deciding to come back to school. I already earned a bachelor's in Mexico, but I was too hard to use it here. So I get my associates in business and also in IT. The fact that right now I'm getting that this support is amazing, because I don't want to live about assistance all the time. I just want to be able to support my family by myself.
What I'd like to say to both everyone who supports the Feeding San Diego program, I'd like to say that it makes a huge impact. I don't know if they all see the impact when they're doing volunteer work or making the donations, but for some of us, it just makes a huge difference in our lives. It may seem like something small to them, but it has a huge
It's all done with compassion. It's well thought out. You care. Like when you open the box, you know, there's a little postcard that says a little message. And for me, like, it's great. It puts a smile on my face and I'm like, I'm not just another number. Like they take the time to make you feel like you're important. And that means a lot to me.
The only way to do a big difference in the world is with kindness, making the difference, be optimistic. We have the chance to survive and do the things right because we have kindness that we need to have. Thank you. Thank you very much.
Thank you very much. I have some flyers at the front if anyone would like to take some with my contact information. If any of you have clients or interested people that you think would want to leave a legacy with Feeding San Diego, we'd love to talk to you. Thank you so much.
Ali, thank you so very much. Every one of our nonprofit spotlights, I learned something new, and what a great organization. Certainly want to alert you to this sheet that's out at the front, courtesy of John Vreeberg of D.A. Davidson. It's if you're a geeky tax person like me, the CPAs or what have you, it's got, tons of information on tax rates, tax deductions for IRAs and filing status and all of that. So thank you, John, for bringing that. Want to get to our speakers. I certainly want to note one thing. Pete Tentler is over here, and he's going to walk up and kind of really just head off to pass around a bowl and say just a few words.
Thank you, Bill. Good morning, everybody. And special welcome to a lot of people who are been here for the first time or haven't been here for a long time. What we do here at the council is that we created the trifecta, and the trifecta is an opportunity for you to get together with two other people, whether it's breakfast, coffee, lunch, happy hour. And I'm going to do my best to pair you up with two other people that are going to complement your industry. So everybody is welcome to participate, whether it's your first time here or hasn't been a long time. So I'm going to pass this bowl around. We'll start here with Robert's table, and then you can pass it all around the back. And if anybody has any questions, comments, or preferences, feel free to reach out to me. Thank you.
Thanks, Pete, Master Networker. Zoomers can also participate by emailing me this morning, and we'll get you paired up. Without any further ado, I want to introduce our speakers. You all have their extensive bios in the meeting announcements, but we've got Kristen Caverly of Henderson, Caverly and Pum, ACTEC Fellow, a giant in the world of estate litigation arena, and Bill Guthrie, Chief Fiduciary Officer of the San Diego Office of Northern Trust. To me, that's the greatest title in the world. Mike Novak with ProFiduciary, experience in the inside corporate trust department for Union Bank for many years, and now at ProFiduciary. They're going to address the question and ongoing challenge of choice of fiduciary. And I added the parenthetical, why do we keep naming the kids? But we'll take it from there.
Good morning, everyone. Thank you for being here. This is probably the third time that Bill has invited me over the last, 15 years or so to talk about this subject. It's near and dear to his heart. And the reason I keep getting invited isn't because I'm a giant of anything. It's because I spend my days litigating, and most of the time, the litigation relates to family members and the administration post-mortem. Breach of fiduciary duty, contests, but mostly breach of fiduciary duty when you're talking about a family member who ends up in litigation. So we wanted to put together this panel. I've worked with Northern Trust extensively. I've worked with Mike as well. We're excited to give you some perspective of the way that issues might arise so that you can talk to your friends, your clients. You can decide if you would want to be named as a trustee and be thinking about the ways that a professional fiduciary might be a better fit. And we're not here to say family members are never the right choice, but there are plenty of times when people that you're working with, asset management, estate planning, tax planning, where you can see that either because of the ages, the sophistication, the busyness, that probably a family member isn't the right choice. And we want to give you some ammunition to talk to those people about why a professional fiduciary or a corporate fiduciary could be a good option, and particularly the myths that you might hear as to why somebody doesn't want to have a professional. So Mike, I want to start with you and just give us an idea of what kinds of cases are your sweet spot and why you might be able to prevent litigation that a family member might not.
Sure. Good morning, and thank you to the council for having us today. First off, for those planners in the room who are naming family members, thank you, because those often become opportunities for me to become a successor trustee. It's really remarkable to me how some families look at internal family members as the right solution to take over as trustee when mom and dad become incapacitated or pass away, because they feel like there's a level of trust or familiarity or privacy because of that family member being the successor trustee. You really need to counsel them to look beyond that. So to answer Kristen's question, my sweet spot is that I often kind of joke with my prospects as I'm being interviewed that I'm Switzerland. I'm the neutral party. I wasn't at the Thanksgiving table having arguments. I wasn't the kid who borrowed a bunch of money from mom and dad and never paid it back. I'm not the kid who got involved in the family business and the other family members perceived took too much money out of it. I get to be that neutral party. So that's how I market myself. Personally, my background is primarily real estate. So most of my accounts are real estate related, but not exclusively so. So that's kind of where I think we fit in.
And Bill, how about Northern Trust? What do you consider to be your sweet spot, and how would you promote naming Northern Trust over a family member, particularly where maybe there's a complex business or a big real estate portfolio and people are going to say, well, the bank's just going to want to sell everything?
Sure. Thanks, Kristen, and good to see everybody. Glad to be here. So Northern Trust, we're a trust company, and we've been in the trust business since the late 1800s and have a really deep fiduciary expertise and a deep bench throughout the bank. Our sweet spot when it comes to serving as trustee is trusts with fair market values of $5 million or more that come with some complications, whether it be there's the clients, the decedent had a business, or there's a complex real estate portfolio. We have a deep bench of professionals throughout the organization with expertise in running businesses, winding down businesses when it comes to real property, managing property directly, managing property managers, getting to know real property, making sure leases are at market rent, things of that nature. When we're presented with a trust that has real estate in it or a business, but it more often comes up with real estate, there is a concern among either the estate planning attorney or the family that, a trustee has a duty to diversify. No trustee wants to hold real property in a trust. Property is going to be sold. This property's been in the family for years. It's a legacy property, what have you. And that's just absolutely not the case. We look at trusts assignments with assets like that on a case-by-case basis. But if we didn't have trusts that had real estate in them and businesses, and then we wouldn't have experts within the bank that focus only on managing those assets within our trust portfolios. So I would say when you're talking to your clients or, about a corporate trustee, the fact that real estate or maybe a business of some kind is in the portfolio is not a deal breaker. And I would encourage you to either talk to me, I'll leave some cards here at the end of the meeting, or have your client give me a call to talk through the situation so we can get an idea if we're named as successor trustee in the future. What kind of assets do you have now? What are the special things we should know about the assets? And just, have a conversation up front so that we can understand what the assignment's going to look like and give your client a degree of comfort that they're making the right choice.
Let's put up the slide, why trustors want to name family the myths. There we go. And the slides aren't really to go through as a point by point, but we do want to talk about some of the ways that you might hear a couple that's doing planning or an estate planning client say, well, why don't we want a professional fiduciary? So we're going to try to talk mostly about those issues as we go through the slides today. And a big one that I feel comes up when there's litigation is the cost. So we didn't name or don't want to name a professional, even an attorney CPA, but particularly a professional fiduciary or a corporate fiduciary, because it's going to cost too much. And instead we should name a family member that we don't pay. How would you talk to that issue, Mike?
I would say that ultimately they wind up being more costly in the long run if that family member who isn't being paid isn't somebody who's dedicated to delivering that service to the trust beneficiaries day after day. I'm thinking of an example that I'm recently brought in where dad had 3 children, named the son as successor trustee, and the son was working with dad managing the portfolio, but for him it was a part-time job. He had a full-time career outside of that and was kind of occasionally driving by the properties and hiring people on his own to work on them at rates that he thought was acceptable. And really what that resulted in was virtually no distributions being made to the family members because he wasn't being attentive to that, his sisters and nieces and nephews. And he also wasn't really maintaining the properties adequately. There's hundreds of thousands of dollars of deferred maintenance in terms of bad roofs, bad balconies, units that were turned over that had been vacant for over a year. And so to really argue that it makes sense to pay somebody zero or near zero because that's going to save money, it's actually cost the family quite considerably. So I think you really have to think about is the family member who you want to have be the fiduciary, are they going to dedicate full-time work towards managing that portfolio? It might not require 40 hours a week of work, but is that really what that person is focused on? Even if they're really tied to it emotionally, do they have the time to really dedicate to managing that trust?
One of the things I would like to see if you do want to name a family member is you should pay them because it does need to be treated like a job. But I would encourage you to think of language other than reasonable compensation, which is what we often see and which is probably appropriate for professionals or corporates that have some kind of hourly billing or rate structure. And what I think would be great is if the family member gets paid something when they make the first distribution, when they sell the building, if that's what the plan is, so that they realize in the trust that it is not the goal to keep these assets. Like you were saying, they're really for the people in the trust. How do we incentivize the family member to make that a priority when they probably are employed otherwise, they have a busy family? So consider incentive payments. And Bill, you talked about the liquidation myth, but I wonder if you could help us understand how Northern Trust would deal with an issue where the family is saying, look, we've got a closely held business, son or daughter have worked in the business, they're our succession plan, they should be the trustee. How would Northern react and be able to persuade that maybe that's possible to keep that person involved or to keep that person in a business position and not necessarily be the fiduciary?
Sure. So I think I would talk to that particular client about the fact that the child who's running the business is, has a full-time job running the business. Being a trustee of a larger trust that includes that business is a job in and of itself. as well. So if you're asking that particular child to fulfill both roles, you're asking them to have two jobs. And at Northern Trust and any corporate trustee, we focus on administering the trust on a daily basis. It is our job to do that. We are focusing solely on the administration of the trust. And, so we can give the, a corporate trustee or, a professional trustee can give the matter complete attention rather than part-time attention. And, depending on how labor intensive running that business is, on a daily basis, that could be different degrees of intensity. You could have a family member that needs to devote 100% of their time to that and really can't attend to the administration of the trust and might not know what fiduciary duties he or she is or is not breaching. So it would be good to kind of have a discussion with the client about that kind of pitfall in it when you're giving somebody dual roles like that.
Another issue that you guys might hear as people are talking about who to choose as a trustee is that my son or daughter, my friend, they can be fair, they know me, they know what I want. And when they say fair, what they may be meaning is they can fulfill the role of a trustee, but most lay people don't really know what that role is. And it starts from the time of the death or when the trust becomes irrevocable. There are certain statutory requirements like giving notice, making sure that people understand the trust, waiting periods, but then there are mundane things like how do I prepare the decedent's tax returns? How do I gather the information? What if the taxes are past due or there are tax problems? What if there are creditor issues? There are a lot of technical issues in fulfilling fiduciary duties beyond just saying, well, mom and dad would have wanted XYZ. And usually the way I see these disputes coming up is the power dynamic. And it is really hard to be fair, what most of us objectively would think of as fair, when you are also self-interested. So most of the family members being named as trustee are interested in the trust and have some share of it and also have some idea what they would like to see done with the assets. It's hard to distinguish those from my ideas as trustee versus my ideas as a beneficiary. I think that's where a lot of family members understandably get in trouble. And Mike, I know one of the things that you will do is meet with people ahead of time to become kind of a consultant for them so that you do understand the family, you do understand what mom or dad would like. Tell us a little bit about how you convince people to let you do that even before they pass.
Sure. So personally, in addition to being a fiduciary, I also provide consulting and asset management services outside of my fiduciary license. So I have some clients who, some of them have named me as a future successor trustee of their trust. Some of them have not. And really what I'm trying to do is get their portfolio in shape so that when I do step in as successor trustee, or if I might get named, things are operating correctly. So I have a client who I'm working with right now who he and his wife ran the portfolio. She's kind of stepped out of the business. They're both older. And he really wants the business to stay up and running after he passes away. So I work with him. I meet with him and his management team once a week and travel with him once a month to look at his portfolio. But over time, I've been instrumental in helping him bring in HR talent into his organization, because before it was just kind of whatever he felt like doing, which didn't always work out very well. I also helped bring in a formal accounting manager. He had a bookkeeper who used to work for him full-time, who was doing part-time bookkeeping for him on the side. That was working out okay, but they really need to bring in somebody a little bit more higher level as his portfolio of real estate grew over time. And also it's just good to have that kind of like separate set of eyes looking at the operation and seeing how things are working. So whether it's somebody who I'm going to be consulting with until I become successor trustee, or even if it's just somebody who's interviewing me as successor trustee and I have no idea when I'm going to step in, I do try and provide that advice about here's how based upon what I know about your portfolio and how it's running, here's my suggestions about how it could run better and how you can limit risk down the road.
We switch to the next slide. And again, we're talking through all of these issues kind of all together. One of the places I've seen corporate fiduciaries, Bill, add a lot of value is where the portfolio is varied. So you might have a large commercial building and you might have a closely held business. You may have other investment assets. Talk to us a little bit about the fact that with a corporate trustee, you can have everything in-house because you have a tax department, you have an investment arm, you have a real estate group, and particularly for a large mixed portfolio where the goal of the trust is a legacy or a decade or two while people get older or whatever the strategic plan is for the business, how a corporate fiduciary can manage all those different pieces. And while you see there's a fee to that, it may be less because you're doing everything in-house.
Yeah, that's a great question. So when I think about, well, the work that we do at Northern Trust, we not only serve as trustee of trusts that people set up, but we also work with living individuals who've hired Northern Trust to provide wealth management services to them. And that most often is an investment portfolio of some kind where we're getting to know the client while they're alive. We are sitting down with them, understanding their entire estate, what they'd like to see happen in the future when Northern Trust becomes trustee. And we often talk about, with Northern Trust, a lot of what an individual might need to do to manage a trust, hire tax specialists, hire business consultants, hire real estate property managers, things like that. We all do that in-house in Northern Trust at one place. We have professionals that can manage oil and gas assets, manage commercial properties, manage residential real property, manage even private equity investments, private investments that an individual may have made as well. And I have one matter that for those of you who went to law school, it seems to always come back to me as like it would be a great fact pattern for a bar exam question because it just has a lot of issues. But we took over a trust that mixed use retail commercial property downtown was one of the assets. 4 retail units on the ground floor and about 11 tenants upstairs in the commercial area of the building. All leases negotiated by the decedent. All leases, all but one, I think, by the time he died, provided for under market rent and renewal options that were very much in favor of the tenants. And over a period of time, through the efforts of our commercial real estate manager who took over managing the property, it took us about 2 years to renegotiate, but we were able to renegotiate or find new tenants for just about every suite in the building and get that building more towards paying, all the tenants paying market rent to the obviously benefit of the beneficiaries. And had we not had a professional in place, the family member that was contemplated as the trustee was somebody who was not a real estate professional and would have needed to rely on advisors to help out and would have needed to even just taken the step to realize that and locate the right people. So it's a good example of when you have a trustee that has all of the resources in house, you can achieve good results for your trust beneficiaries or your clients. And we have a tax department. We have tax advisors that can help with tax strategy. We even have a dedicated generation skipping tax professional within the bank that advises us on GST tax issues that come up in trust. And I think it's fair to say that the GST tax is probably one of the hardest to understand taxes and one of the hardest, especially if you are, not a professional and don't see that particular term come up, every day. So we've been able to achieve some really good results saving GST tax for in trust as well. So I think that, when you have a client that has a complex balance sheet with a lot of different types of assets beyond your typical cash, stocks and bonds, Having a trustee that has capabilities in-house, over the long run is going to be, number one, probably cheaper on fees, but also maybe avoid litigation and the fees that go with that. If there's any kind of discord within a family, if an individual is managing those types of assets.
Great. Next slide. And as you can see, as we've been talking, the purpose of the trust matters a lot when you're thinking about the type of trustee and whether a family member would be appropriate. So we often think about trusts as just the postmortem vehicle, and that's certainly very common. I don't want to go through probate. I want to make sure that the family gets my assets as soon as possible. I always think it's cheaper to go through trust administration than probate, which isn't really true, but maybe it's privacy that you want, but you're really just looking to distribute those assets. I would certainly still consider a professional, or as I mentioned, incentive payments or some instruction to your family member about the expectations. Because as Mike mentioned, a lot of times professional corporate fiduciaries get involved when the court appoints them. And I find that typically starts to happen when the person who's been chosen, the family member, isn't getting the trust administration done. So 6 months have gone by and the house still isn't for sale. And maybe the person lives in the house for convenience. Maybe no distributions have been made and it's been 2 years. Maybe no information's been exchanged about the estate tax return or the appraisals for the property. The business hasn't made any distributions to the shareholders. So if you are going to name a family member, encourage the trustors to put in their expectations. Obviously, you can't tie the trustee to an exact timeline because you don't know what the circumstances will be. But it would be, I think, important if the parents, let's say, who are doing the trust suggested that initial distributions of half of the trust should be made within 12 months, for example. That might at least tell the trustee what to have in terms of expectations and also the other siblings, so that you don't have 6 or 8 months go by and then there's a petition with the court to remove the trustee and order an accounting, et cetera. The court's probably going to take another 5 or 6 months to even hear that petition. And now you've got litigation going on amongst the family and most likely fractured relationships that are going to last throughout that trust administration, if not the rest of everyone's lives. So even for immediately distributing, I think a choice of professionals is still something that people should seriously consider. Other trusts are set up to care for family members. So maybe it's the second spouse to die. And I've certainly seen a lot of litigation where that second spouse ends up not following the terms of the trust. Certainly, come to mind a mixed family where you have children from a prior marriage. But it also happens when the surviving spouse is the parent of the children, because things happen over the course of a long period of time and alliances change. Maybe the trust is never even funded. Maybe the distribution provisions aren't followed. A professional fiduciary or a corporate fiduciary isn't going to run into those problems. And you can split between the B and C trusts and the A trust. So the survivor gets full control of their own assets, but the assets that are set aside from the decedent would have more protection. Managing property or business interests, creating a legacy long-term, that's certainly where you would have a lot of incentive to consider a professional or a corporate fiduciary and talk to your clients about, yes, you may be naming that child now, but what if you don't pass for another 20 years? That child is 70, they're not going to be the person who's going to be the right fit to manage this portfolio or this business and see it through another generation. So what kind of choices could you make to have longevity in that trustee position? Okay, next slide. This next half of the program, we want to talk about some scenarios. So we've talked about generalities and fits for when we can add value with a professional or a corporate fiduciary. These scenarios come straight out of my practice, and they took me about 10 minutes to put together. And that's because there are many more where these came from. And of course, I have changed, there are no names. I've changed the facts so you probably couldn't recognize them even if you were opposing counsel. But I chose them to illustrate the types of situations where seemed perfectly normal to name family or multiple family, which we'll talk about, but it ended up in litigation. And your clients will tell you, that's not going to be my family. And 90% of them are right. I never met those families. So there's certainly lots of them. I'm sure this works. They pass the assets. Everyone still enjoys Thanksgiving together. We're here to talk about the alternatives when, if you were really honest about the dynamics of your family or about the dynamics of your assets, it probably is not the best choice to saddle your lovely son or daughter with the task of doing this administration. So scenario one, the decedent had no children, not married. And as he was older, he named his brother trustee, who was also older. The trust term's supposed to distribute, right? All of these beneficiaries are in their 70s and really could use the money. The assets were fairly normal. We had a residence and a business entity and some investment assets, a few $1 million, but money that really would make a difference to the beneficiaries and that certainly the decedent expected them to have. This trust has not been fully distributed, by the way, and it's still in litigation. The business entity, as it turned out, hadn't paid taxes in quite a while. That was something that the decedent decided wasn't worth bothering with anymore. And the business entity was the owner of the decedent's residence. The brother who was the trustee, when he became the trustee, of course, you needed to sell the house. So he transferred the house out of the business entity and into the trust and then sold the house. That was all that had been done by the time he was removed as trustee by the court, and my client was put in, a professional, to try to fix the tax problem primarily. And if any of you have been dealing with tax problems since the pandemic began, you will know that we are still dealing with the tax problems. So it's become a very long process to get refunds and get the IRS and FTB to act on things. But we had to go back many years, amend returns, and now wait for refunds, wait for bills. And there's still, the court is holding off on the litigation with the brother trustee until all of the income tax issues are sorted out, because there's no point in going on with the surcharge breach of fiduciary duty litigation amongst the beneficiaries until we really know what the cleanup is. So whether or not people will ever enjoy these assets or an additional generation will pass, it's a really unfortunate situation. And the legal fees and the CPA fees, and in part just to take care of decedent's mess that he left, but then to undo the mess that was further created by somebody who didn't understand the business entity and the tax implications of taking the assets out and basis and that sort of thing. But so, Mike, let's say this is a $5 to $10 million trust, which was about right. What would you do, not when the court puts you in, but what would you do when you find a decedent in that situation and you're named as trustee?
The first thing I would do in this situation would be to talk to my legal counsel and tax counsel. I would be concerned that there would be tax consequences of spinning the real estate asset outside of the business entity, especially since the business entity had not filed tax returns for such a long period of time. may have to revisit whether to transfer that asset back into the business entity so that the business entity had, I don't know what the situation was, but the business entity may have needed the sales proceeds from the sale of that home inside the business entity in order to pay the taxes that it owed. So that would be the first thing that I would do. I think, the tax issues are really the ones that really slow down the closure of trusts, I think, as all of you know. My colleague Danielle Campbell and I are co-trustees on a trust right now where the decedent had never created an estate plan. Not only did she not name a family member, she didn't name anybody. So Danielle and I were hired by her about a month before she passed as powers of attorney, and she became very sick very quickly. And so we executed a trust on her behalf. But during that intervening month, as we're going through the mounds of mail in her retirement home, we found out that she just decided not to pay taxes for many years. And the state and the IRS were filing tax returns for her based upon the 1099s that they were receiving. But we're still, we went into tax reserve for her trust at the end of 2022. And here we are 24. And we're still having difficulty getting our CPA to get the IRS to acknowledge that she's the party who they can speak with to resolve these tax issues. So that's how messy and time consuming can be to solve that kind of an issue.
I think one of the most important things that Mike just said stands to be reiterated, which is, what would you do, Mike? You would hire an attorney, you would hire tax counsel, you would be able to issue spot. And so the decedent left this a mess. This really wasn't the brothers' trustees' mess that got created, but he was not in a situation where he was capable of sorting out these complex issues. And even if he was named, he could have declined to serve. Sometimes attorneys would be serving their clients very well by simply telling them not to accept that trusteeship or to resign if it turns out you get in and you see this is a big mess that you aren't capable of handling. A professional, I think, is in a far better position. And this was Bill's point about Northern Trust, where they have all of the departments in-house. You wouldn't have wanted this particular matter. But it is the person who is the quarterback. It's the person who issues spots. It's the person who gets the property managed, files the taxes, does the business entity, rather than the person necessarily in the family who would even have the first place to call or to start with that. And to add to this, a brother wasn't even in California. So it's just a really challenging job. I'm sure he felt obligated to accept out of duty, but it was really a bad thing for his brother to name him. So if we could go to scenario 2. The decedent in this particular case left 4 children, all capable young adult professionals. He named the eldest child, as you so often do, as the trustee, because that's the benefit for being born first. The trust was supposed to distribute, and primarily it had a beach house up in Santa Monica, very nice property, not a place that you'd want to go if you had just spent $4 million on it, but a place that you'd love to tear down and build your new house because you just can't find that property. But a couple of the beneficiaries, including the trustee, thought that it would be a great rental property. And a couple of the beneficiaries thought it would be really great to have their $2 million. And a standoff ensued where just nothing was happening. So the house wasn't being rented, it wasn't being sold, distributions weren't being made. There were some proposals from the trustee of putting it in an LLC. And you can imagine that one beneficiary immediately raised her hand and said, absolutely, that's a great idea. The other trust beneficiaries said, no, that's not a great idea. And when I was consulted, that's where it was. Really nothing had happened. And it was a standoff because the trustee had a self-interest in the outcome. So let's add another 0 to the beach house, or some other assets that make this. I think your sweet spot would probably be closer to 10 million. And how would Northern come in and resolve these disputes? Because we have a difference, people don't want everything liquidated. So are there some creative things that Northern could bring to try to help resolve that? But also, how would you deal with the disputes amongst the beneficiaries? Even if you don't have a solution, tell us about how you interact with the beneficiaries when there is a dispute, NOPAs, court approval, resignations. Because one of the problems for family members is they get into the situation, they're in a dispute. What do they do? And I think it was Mike that said, he's Switzerland. And I think that's a place where a corporate trustee too can offer possible solutions, but then ultimately has the resources to go and bring this to a court if it were necessary.
Sure. Whenever you name a child, this is a perfect example of, one of the children having, sort of a conflict of interest in the sense that they have their duties as trustee, but they all, which are fiduciary, and they have their interests as a beneficiary, which is personal. And those two are clashing here with at least child one, who wants to, maybe purchase this piece of real property along with their sibling. So right off the bat, whenever you name one of your 4 children, they're going to on day one have that potential conflict between their personal interests and their fiduciary interests. If Northern were the trustee of this trust, our job is to be the objective voice. Look at things objectively. We're going to have a deep history of managing estates where issues like this can come up, as well as just managing property. Maybe we have had some solutions in the past in similar situations. We can consult our real estate department, other offices, see if we've ever had any success with a particular avenue. But the best we can do here is as a trustee, if we were the trustee, we have a duty to treat all beneficiaries equally and impartially. So we need to give every single beneficiary's voice equal weight. And depending on what we're hearing from the beneficiaries, if they have competing interests or competing ideas with respect to how the property should be handled, we'll try to resolve it first through communicating with the beneficiaries. If that's not working out in any way, we can propose solutions, propose options, see if anybody, we can get like unanimous agreement. Maybe it involves going to court to bless a particular plan and make sure all the beneficiaries don't object to it. Maybe it's, as Kristen mentioned, handling it in the way of issuing a notice of proposed action to the beneficiaries and make sure that everybody agrees with the proposed solution with respect to the beach house. Maybe there's a way to, for beneficiaries to purchase and finance to the benefit of the beneficiaries that don't want the real property. I could see a lot of different potential solutions here, but we would start with leveraging our internal expertise to come up with a couple of different options to discuss with the beneficiaries to see if we can't get to a resolution on what works best for everybody.
Just one quick comment on this, and this one line in here about how some of the kids wanted to start operating a rental. This doesn't happen all the time, but it happens often enough where I have to have a much more gentler conversation than the way I'll communicate it now. But terminating trusts and estates are not new business opportunities for the family. This is not when we start trying something new and different. We certainly have responsibility to maintain a real estate portfolio or an operating business to distribute it out if that's what the plan says. But this is not a time for us to start taking risks like mom and dad used to do. I have to tell kids that all the time. I'm a fiduciary. We can't take the same kinds of risks that your parents were able to do during their lifetime.
I've actually seen an uptick recently in beneficiary ideas that real estate should be used, utilized as an Airbnb rental or a Verbo. Well, I guess they're the same now. But operating a property as a short-term rental, that just opens up a whole new can of worms with insurance and other matters. But I see that as becoming probably more and more prevalent in beneficiaries' minds, given the, the rise in our utilization of Airbnb type properties.
All right, let's go to scenario 3. Decedent died, left 4 children and a second wife. Everyone was named as a co-trustee. No, you know this is going to work out. And the trust purpose was to hold a large real estate portfolio for about 10 years, throw off the income to everybody who was also a co-trustee, and then ultimately the trust will terminate and distribute. Like most real estate portfolios, there was not a ton of liquidity because the decedent had lived on the cash flow and had not reinvested a ton in the properties. So you've got a really nice real estate portfolio, but not another $10 million in cash, and you have deferred maintenance. So it's pretty difficult to look at the cash flow from the year before decedent died and project for the beneficiaries that that's going to be your cash flow for the next 10 years. So they could not get along. They could not agree on the property management, and a corporate trustee was appointed when they all ended up in court in litigation over what to do with the assets. To me, this is the perfect sweet spot for a professional, either a private fiduciary or corporate. It's a large portfolio. It has a long term, and you have people who should not need to ever speak to each other again if they choose not to. And the decedent's property is now very productive. There have been some strategic sales, some strategic improvements to some of the remaining properties. Everyone gets their distributions. Everyone gets a monthly statement, so they know exactly what's going on at any moment of the day. We don't have group meetings because they don't like each other, but the trustee meets with the individuals and talks about plans and tries to elicit their input. And that's something that a family member often will have a hard time doing. If I come into a matter where the court has appointed my client fiduciary, we will start with meetings. And if I come into a matter that's not contested, where I'm representing the trustee, we will start with meetings. Now, they might be a group meeting if everything's going well, or they might be individual meetings. But I think the best thing a trustee can do, family or professional, is make sure that the beneficiaries know that this is not your money. And the way to do that is to engage with them and tell them what's going on, what the assets are, provide appraisals, provide plans. You can't always, as Bill was saying, get everyone to agree. And sometimes we do end up in court with an instruction petition. But you can make sure everyone feels heard and that everyone knows that you will be treating this money, these assets, as if they belong to someone else. So, Mike, I know that you are particularly experienced in real estate in San Diego, and you and I have worked together on a large commercial property, so I've seen that in action. If you were named as trustee in this scenario, what might your plan be for dealing with the properties, dealing with the low liquidity, trying to keep everybody informed?
I think the first thing that I would do would be to, if they haven't done so already, is obviously get appraisals and broker opinions, because oftentimes those numbers are very different from one another. Share those with the family, and then put together some calculations of what the returns on those assets are. Are the returns actually decent, or are they poor? If they're heavily leveraged, we need to look at what the cash flow is at the end of the day. I think the best thing that any fiduciary can do when you're looking at a complicated asset portfolio like this is to put together cash flow projections. My favorite ones to put together are the ones that show that something isn't working. Because oftentimes a family member will come to you and say, I had this great idea. I always told dad I wanted to do X and he never would. And if we do that, we'd make a bunch of money. I love putting together a cash flow projection for that because more often than not, it shows plain as day, it's not going to work. So I think it's really critical to gather the information and put down those projections. Some of the family members, you're really going to have to struggle with getting them to walk through it and understand what's going on. But that's really the way that you're able to demonstrate option A is going to work, option B won't work. And that's really at the end of the day, what you have to be able to communicate to them is why you want to make a particular decision. You want to paper your file as a fiduciary, one, about why you thought it was a good idea. Might seem clear as day to you off the top of your head what you should do, but putting that quantification of what the plan is and then communicating it to the family, that's invaluable. That's invaluable to you for managing your risk as a fiduciary. And it may not immediately work with the family, but as you kind of use that process over time with the family, you're going to find that they understand that what you're bringing to them is valid information that explains why you're making a particular decision.
Great. Let's go to scenario 4. Decedent left 3 children and her husband. The husband was named the successor trustee. That's what everyone does, right? A husband and wife, joint planning. One of them passes, the survivor is going to be the sole trustee. See that all the time, and it probably works most of the time. But what I've seen happen and what happened in this case is the survivor did not fund the subtrusts. We can look back because we were looking back after he died. We can say that that was intentional or it was just negligent. But I think it's a lot of times intentional. And as a planner, you should be mindful that when you're representing 2 parties, you always get your conflict waiver, but there is an inherent conflict between those 2 people. Obviously, you're thinking about divorce and those sorts of things. Maybe they don't agree on the plan, but one of them is going to die first. And if the other is named as the sole trustee and the job is to hold the assets for someone that the first spouse wanted to have them, mostly children, there can be a lot of things that go on after that first spouse dies. And the typical is a second marriage or third marriage. And that's what happened here. So the trust was supposed to be split between A and B, held for husband, and then ultimately to the children. He remarried, and at his death, nobody asked any questions at mom's death. You know, you're not going to ask for a copy of the trust. You're not going to ask if you get anything. But when he died, the asset manager, the corporate fiduciary, actually was the savior of the day here, because the asset manager who had the investment account had a copy of the trust. And that's the only way that my clients figured out what the original trust was. And then we got the investment manager. I really wish I could even say who they were, because they had correspondence that they had kept with the decedent. They had encouraged subtrust funding, which the decedent had chosen not to do. And without their files and their willingness to step up and say what they had, my clients would have completely lost out on their inheritance. So I say this also to encourage you that if you're in a fiduciary position, if you're the CPA, the investment advisor, to make sure that you get a copy of the trust if you can, if that's a trust account. Make sure you know who the successor trustees are when you get that affidavit of change of trustee. You might be the only person that is in a position to help that trust be administered properly. But Bill, what I'd like to ask you about, so let's say that Northern has been involved in the investments, and that's one of the things that you mentioned you could do ahead of time. If you found yourselves in this situation, have you, and sort of how would you interact with the original family? Would you be willing to serve as trustee and try to do this forensic accounting to get the trusts? We had to unwind what was done and ultimately get them in the right pots. And by the way, the second spouse didn't know anything. Like, she was completely innocent, but it did take quite a while to get back through all the historic documents and get the money in the right place. And of course, everybody had lawyers.
Right. Yeah, this brings up something that I think is very important. And, oftentimes I'll receive a phone call from an individual who, wants to talk to me about what a corporate fiduciary does and how, what does it mean for Northern Trust to be a corporate fiduciary? And a lot of times it's presented to me in terms of, we don't really have anybody that we want to name as successor trustee. So our attorney has recommended that we reach out to corporate trustees, and I want to learn more about this. And a lot of times the mentality for just people that are doing their estate planning is they just want a name to put in their trust. And I talked to them about, well, if you're going to name a corporate fiduciary in this capacity, you should really get to know us while you're alive, and we should get to know you. We should get to know what your trust document says if we're going to be in a fiduciary capacity at some point. We should get to know what your assets are, so we know, how we might handle your trust, and we can talk to you about that. Why not open up an investment relationship of some kind while you're alive, so that we're having regular interactions with you throughout your life? We know who your estate planning attorney is. We know who your CPA is. I've encouraged, we're working with you. We're talking through estate planning issues and investment issues periodically. Maybe you say something to me that makes me think, oh, I think we might need to amend your trust. Would you like me to reach out to Kristen or whoever your estate planning attorney is to kind of prime them on what we're talking about? It's really important to have that working relationship, I think, with clients while they're alive, so you know what their estate plan says. And then if it's a husband and wife situation and one of the spouses has passed away, you're there to guide the surviving spouse. Talk to the surviving spouse about, all right, what happens next now that you're the sole trustee? Your trust calls for division into an A, B, and C. Let's work on that. Let's make sure we're getting that done on time. So if we have an opportunity to work during our future appointment, our successor trustee appointments, if we're having an opportunity to work with those people while we're alive, the advantage is, continuity. The family has somebody that, even if they weren't privy to their parents' financial affairs, Northern Trust was, and we have the information to fill the gap, and we have a plan for moving forward. I have, over the years, we've had a couple of trusts that have come to us for administration that we accepted, where we did have to go back. There was one that I can think of, more than 10 years. Spouses innocently don't realize that they need to divide the trust up. They don't go to their attorneys upon the first death, where they would have been, maybe clued in to the fact they needed to do that. And then you have some surviving spouses that don't like the idea of having to manage 3 trusts and knowing that the B and the C trust are irrevocable, and I have something less than 100% ownership at this point. Like, all the things that were talked about in the estate planning process are kind of just disregarded because the importance is not appreciated. So we have had some of those come up, and oftentimes we'll do a lot of work internally and with the clients' outside advisors to kind of do the forensic accounting and figure out, what should be in these different trusts. We've even had to go back and not only kind of reconstruct ABC trusts, but also reconstruct and do qualified GST severances for trusts that weren't divided into GST exempt and non-exempt shares, which, can have some pretty big tax consequences if you can't, demonstrate what's exempt and what's not. So we have the ability, we do find ourselves doing that a lot. And I really think it's important for people that are contemplating a role in the future to not just think about it as something that's going to happen in the future. And that would go with any corporate trustee or professional trustee. Get them involved, get involved with them while you're alive. Encourage your clients to do that.
We've got a couple more scenarios. Bill, are we still okay? Okay. So let's go to scenario 5. Decedent passed with 2 children. named the first child as trustee. The trusteeship is the total prize for the eldest. And it does seem like a prize until you get sued. And then maybe it's the booby prize. Just supposed to be distributing a local family real estate portfolio. Seems like it's easy to get $10 million in real estate in San Diego. I don't know how, by the way, but it does seem like it's easy. And again, the child made no distributions. And one of the reasons is because she wanted to purchase one of the assets in the trust, the largest building. And there probably was enough in the trust to accomplish that, but you have to agree on a price. And that's always a challenging thing to do between siblings. So the trustee or whoever wants to purchase it, it doesn't have to be the trustee who wants to purchase it, but they usually want to take advantage of tax basis or lack of commissions or a variety of other savings that the beneficiary that's selling is going to get out of this transaction. And they don't want to get appraisals, and they don't want to get opinions of value. They certainly don't want to put it on the market and make an offer and see what in fact the market will bear. And so without having agreement on those things, months just slip by. And there's no distributions being made from any of the assets. My client came to me out of frustration, and it's been 3 years, very patient person, but it's been 3 years and nothing's been distributed. And unfortunately, I've seen these too many times to think we're going to just right the ship, because of course, either the trustee doesn't have counsel, or they're not listening to counsel, or counsel isn't letting them know that they're about to be removed by the court. And so we ended up certainly demanded some distributions, didn't go very well, and then ended up in court. The litigation is over, but unfortunately, the trustee beneficiary passed away during the course of that litigation. And it's just to say that a lot of our people die, their kids are already older. It's such a shame if the trust cannot get administered and get distributed so that people can enjoy it. And instead, people like me are creating an entire business out of being able to get trust distributed that should have been distributed a long time ago. And yes, I do have a mortgage and I have kids in college, but it's really a travesty to see the assets that people put together over their lifetime just be destroyed. And of course, as you might guess, everything in this portfolio ended up getting sold by court order. It happened to be during the pandemic, so it probably didn't end up being the ideal time for everyone. And the one sibling passed away without ever having the opportunity to enjoy the assets fully. And of course, the relationships were fractured. So Mike, again, I see, and there's so much wealth in San Diego with real estate. I see this again as something that you could see day in and day out. How might you deal with the kids when one of the beneficiaries wants to purchase assets, either distributing assets in kind but not pro rata, trying to get funding by the trust borrowing money, selling some assets? Like, how would you try to be creative to accomplish what both of the beneficiaries wanted, if that's possible?
It's rarely possible. I really hate private sales of any form, whether it's between family members or two people, a neighbor who wants to buy your property. They're always not a great idea for a fiduciary. And the reason is that you may think, oh, the property appraised for $1 million. He gave me $1 million. I didn't pay broker's commission. Well, that guy could turn around and sell it tomorrow for 1.5, because somebody out there in the open market might pay 1.5. You, as the fiduciary, are probably going to get looked at by the beneficiaries for that $500,000 you left on the table. So in my entire career, I have only approved facilitated 2 private sales, and they were really unusual fact sets there that I thought warranted that situation, those private sales. If I have family members who say, I want to buy this out of the trust, I'll pay whatever the appraised value is. My answer to them is, well, you can buy it when it's on the open market, and they'll come back to you and say, well, I need my distributive share from the trust in order to be able to afford to buy that property. Well, fine, I'll work with you. We'll find a broker who will pay a commission, a fair commission for putting it on the market, but you're going to have to compete and pay, what the open market's going to pay. Nobody has ever accepted that offer for a good reason. They're not going to get the deal anymore. They no longer want the property. They know they're going to have to bid it up with all the other people who are interested out there. So if you put them in a scenario where they have to compete just like anybody else in the open market, that super strong desire to get that property usually withers away. So I think that's the best way to approach a situation like that. Also, as a fiduciary, again, you want to get an appraisal, of course, and I always try and get at least 3 brokers' opinions. If it's kind of an unusual situation, I've gotten as many as 5 broker opinions on properties before. You're going to see a range of values in there. None of them are going to be what that beneficiary wants to pay for the property. And that's also how you can say, look, how can you tell me as a fiduciary I should sell it to you for X when it's X plus 20%? So I think that's a good way to combat that criticism too.
Great. Scenario 6. This is the one that Bill has already shared with us. And I think this is a sweet spot for a corporate fiduciary where you have a legacy trust. It's intended to produce income for a variety of people. Nobody has either the experience or the time or the desire to run the property. And a corporate fiduciary can see that property through a very long life, make the adjustments, deal with tenants that the family members may not want to deal with, get those back up to market rents, and then make sure. I love corporate trustees, monthly statements to everybody. The trust is run just like an investment account. So you get your monthly statement. It shows if Susie got a distribution. It shows if Billy got a distribution. It shows the income. It shows the taxes. And you really don't have to even have the meetings, but certainly I'm sure that Northern Trust does if beneficiaries want to. But keeping beneficiaries informed is another place I think where professionals excel. So doing your annual accountings, providing copies of tax returns if people want them, providing monthly statements. Again, it goes a very long way if people who are the beneficiaries know that the trustee is treating the money as if it belongs to the beneficiaries and not to the trustee. And all those communications with accountings, with statements, with notices of proposed action, that tells the recipient, hey, everybody knows this is my money and that I'm getting what I'm supposed to get under the terms of the trust. And then just our last slide. I thought this sums it up. Mr. Gordon is a talent agent, and this is really the crux of the problem for family members is many of them are good people. They do want to be fair. They do want to do what their parents wanted. But it is very hard not to be guided by your own interests, whether that's the interpersonal dynamics or the financial aspects of the trust administration. And many of our estate planning clients would do their families a favor if they were reasonable and looked at before they die, a professional relationship with a professional fiduciary or a corporate fiduciary. It would make the assets much more valuable and get them in the hands of their beneficiaries much faster. And that's really the goal of your estate planning. So why would they want to put in a trustee that's not going to accomplish their estate plan? Thank you. And we've got a couple minutes, maybe a minute for questions if anybody has. Mr. Sullivan.
Do you guys work as co-trustees?
We will, but it's very important, like upfront in those situations, to kind of set the tone of the relationship, who's going to handle what, make sure we're all in agreement. But yeah, we will do that for sure.
Mike, how about you?
Generally, in our firm, we do not act as co-trustees with persons who are not part of the ProFiduciary group. There's exceptions to that. So if I know both spouses very well, then possibly. If I was interviewed recently, it's only been over the telephone so far by the wife who called me up and said, we need a successor trustee. My husband's failing. We have $1.4 million, I think, or something like that. It was not a huge amount of money. And then she called me up 10 minutes later and she said, sorry, it's $14 million. Sounds super sweet, but obviously she's been left out of the money management. So that's somebody who I might work with. So we generally say no, and then they agree to let us serve a loan, but we can.
One more, George.
What's a typical range of fees for professional trustees? What do you recommend if you have a family member doing it who, let's assume the family member is pretty confident that the job is the best interest of the beneficiaries?
Well, the court will give them $20 an hour, maybe 50. And people are regularly offended because their time was so valuable. People quit their jobs and they shouldn't. They should hire professionals to do the work. So I had a person who spent 2 months cleaning out the house. She should have called Mr. Horn, because the court's not going to pay you to do that kind of stuff at $100 an hour for 40 hours for 8 weeks. It's not reasonable. Mike, how about you? How do you charge?
Our fees are charged based upon a percentage of the market value of the assets, just like banks charge typically. It's tiered. You're welcome. I don't know if you guys know, but fiduciaries, if you have a website, you have to publish your fee schedule now. So if you visit our website, the fee schedules are published there.
Same with Northern, graduated percentage of assets under management starts at, for a trustee appointment, starts at 1.2% and down from there. Yep.
One more question. I think we have time.
Will a professional trustee or fiduciary ever carve out or allow an estate to carve out an asset, a well-run family business or family real estate portfolio, because it's minority interest, you can't impact it, and therefore shouldn't be charging fees on that asset? Whereas there's other assets that they definitely need help with.
There's always going to be a degree of, the trustee is always going to have the ultimate liability for breach of fiduciary duty if things go wrong. So normally we don't have no fee assets. There can be custom situations where we negotiate a fee based upon the situation.
And you might want a separate trust for that asset, and that one gets the family member.
I think with the exception of grantor occupied homes where they're competent living there, managing it, then we would have a special fee arrangement for that. But beyond that, we can negotiate a fee around something like that, but we wouldn't charge no fee.
Thank you. We'll be around if anyone else has questions.
Thank you all so much for coming to the March meeting here. So many years of experience and expertise with these folks. We all can help as far as this process, as far as dealing with things ahead of time. So certainly take advantage of that. If anybody has questions on the June 17th extended due date, let me know. And then our April 2nd meeting is on how to communicate with your clients on philanthropy and charitable giving. Thanks.